he had hired left waiting at the front desk, barred from reaching him. Warren's principle is the reason that scene unsettles us. Not the guilt or innocence of any one suspect, but the spectacle of a government drawing a confession out of a person it had sealed off from the world. And so we arrive back at the question the court set out to answer. Can the state hold a man in a room cut off from the world, press on him until his resistance gives way, and then use his own words to convict him? The court's answer was no, not because a confession is worthless, and not because the guilty should walk free, but because a free society places the burden of proof on the state and leaves it there. The government must build its case from its own evidence, gathered by its own effort, not assembled out of words wrung from the accused in a place where no one is watching. If the state still wants to question a suspect, it may. But first it has to do the one thing the closed room was designed to prevent. It has to tell him he does not have to answer at all. That is the price of the principle, and the warning is how the price gets paid. For Ernesto Miranda, the consequence was immediate. The confession taken in that Phoenix interrogation room had been obtained without any warning of his rights, and under the rule the court announced that day, it could no longer stand. His conviction was reversed. But the case was never really about one man. Out of Warren's opinion came a handful of sentences that left the law books and walked into ordinary American life. The right to remain silent, the right to an attorney. Words now repeated so often, in films and on television and on street corners, that most Americans can recite them before any officer ever speaks them aloud. That is a rare thing for a Supreme Court decision. Most are read by lawyers and forgotten by everyone else. This one became something closer to a ritual, a sentence the state must say out loud before it takes anything from you. A reminder, spoken at the worst moment of a person's life, that even then the government owes them something. Warren had called it dignity. The idea that a person facing the full weight of the state is still a person, and that the state, to stay worthy of the word free, must prove its case without reaching into his mouth to find it. That was the question these cases asked. And that was the no windows and a young man inside it, his hands cuffed behind his back. Across the table sit the men who have been questioning him, and they have just played their strongest card. They tell him an accomplice has already talked and named him as the man who fired the shots. He does not break. He turns the accusation around and throws it back across the table at the very man accusing him. His exact words, as the Supreme Court would one day set them down in the record. "I didn't shoot Manuel, you did it." It did not save him. He stayed on his feet for the next 4 hours, question standing, while the attorney he had already hired waited just down the hall, asking to see his client and being turned away. By the end, the police had their confession, and years later a court would rule that those words could never be used against him. What happened in that room reached down to the roots of American justice, to a single question the country had never squarely answered. Can the state lock a man in a room, wear down his will, and use the words it pulls from him? Or must it first tell him that he can stay silent and that he can call a lawyer?